So without further ado, we will get to our speaker today. So Logan Phillips is a local attorney here in Columbus. I've gotten a chance to see him present his work and learn a little bit about him. Um, the side of financial wellness and the legal issues around brain injury almost always crop up for someone who's going through it or their caregiver. And we think that this is a really great place for us to get armed with skills, with understanding, with experience that can help avoid those stressors, avoid those delays, avoid those unknowns. And that might be something that over time can also be therapeutic for you. So we're really, really excited. I've been waiting quite a long time to do this one. So I will have Logan introduce himself and then get into his experience and his advice for you. So thank you, Logan.
Hey, thank you, Kadar. I appreciate the chance to talk with this or with this group. I must tell you that I didn't know Zoom existed 3 months ago. So please forgive any technical difficulties as I try to switch screens, perhaps. I'm learning as I go. I've enjoyed presenting at the TBI Summit. And this is just, I think, an extension of that. You might already see that I've put some things in the chat. Although this meeting is being recorded and the PowerPoints will be provided, today's presentation is really just the tip of the iceberg for information, and certainly don't feel like you need to retain everything. So that's why I've put the 2 links in the chat. Those are links to books that I co-authored for the Ohio Developmental Disability Council that go through guardianships and alternatives, and then also estate planning for individuals with disabilities and those who love them. And it talks about trusts and the stable account and SSI and SSDI, all of the things that I'm going to touch on today. Tonight we're going to talk about estate planning considerations, and we're going to talk about Medicaid and SSI, the basics about those. We're going to talk about special needs trusts, stable accounts, guardianships and alternatives, and then advance directives. So who needs special needs planning? Well, special needs planning is needed by those individuals who have some type of disability that allows them to receive government benefits. And those benefits usually take the form of Medicaid, Medicaid waivers, or supplemental security income, commonly known as SSI. So these programs are what are called means tested. And the easy way to think about that is if you have means, you don't get them. So if you have money, you are ineligible for these benefits. So the reason that I have a job, the reason that people come to see me is because the resource limit, the amount of money that an individual is allowed to have and still receive these benefits is $2,000. Now, there is a higher limit for those individuals who are working. That's $12,382. But for most of my clients, $2,000 is the limit that we think about. That means that if you have more than $2,000 in your name, whether that's in stocks and bonds, whether that's in gift cards, whether that is in a checking account, you are ineligible for Medicaid and SSI. So what I do is I help people to get eligible for these programs and also maintain eligibility. And I do that working with families to make sure that they don't leave money to a person with a disability and cause them to lose these benefits. So the concerns for families that these benefits and these trusts and the things we're going to talk about really help or are geared to provide are services, whether that's day services, whether that's in-home care services, transition, housing, employment, day services, and then benefits. So let's talk about Medicaid generally. I've already said that it's a need-based program. So most commonly we hear about Medicaid as something that senior citizens might need. They need to go to a nursing home and they need Medicaid to pay for. Or a person who is low income qualifies for Medicaid through the Affordable Care Act. But individuals with disabilities are eligible for Medicaid and really a special type of Medicaid called Medicaid waivers. I'm sure many of you have heard those words before. And a Medicaid waiver is the opportunity for individuals with disabilities to live in the community and get services in the community rather than having to go to a hospital, a facility, or an intermediate care facility. So let's talk a little bit about that. The history of the care for individuals with disabilities has not been great in Ohio. And it starts, it starts from Ohio and the federal government. You can lay blame in lots of places. But the federal government provides the money for Medicaid. And their rules when they started doing this were, you, state of Ohio, must use this money to have state-run hospitals and facilities for individuals with special needs to get their services there. Well, what does that mean? That means that many people without supports in the community needed to live in a facility. Those were called institutions. And the abuse that went on there was horrific at times, but it was also expensive. And so states like Ohio said, we don't like doing this. So federal government, will you waive your requirements that we have to have these facilities in different parts of the state, and instead allow us to develop a program to meet the needs of our constituents in the community? And that is called a waiver. So the federal government waived certain requirements, which is why we now have Medicaid waivers, okay? There are 3 waivers that are established in the state of Ohio and that are provided. Some of you may be on them. That's called IO waiver, a self waiver, and a level 1 waiver. If you're not on one, or you are interested in becoming or getting on a waiver, you should go to the County Board of Developmental Disabilities and seek their advice about how you might obtain one, okay, or other services. Now, the County Board of Developmental Disabilities assists individuals whose disability was diagnosed before the age of 22. However, if your disability occurred after the age of 22, the county board can put you in the right direction. Sometimes you will go to the Central Ohio Area on Aging to get those services. Okay, now, so what happens is 2 different agencies are involved in these waivers. First, you have the county board who determines, or the Central Ohio Area on Aging, who determines whether you need a waiver or services. And then you have the county Job and Family Services that decides whether you are financially eligible. So that's what waivers do. And so when thinking about long-term future planning, I suggest that individuals determine their eligibility for Medicaid and Medicaid waivers. Now, the waivers that I just described the level 1, the IO, and the self waiver are those for developmental disabilities. They have other waivers that are for individuals who are older than 22, or excuse me, that's disability occurred after the age of 22, and those can be detailed at the Central Ohio Area on Aging, or by Googling waivers, state of Ohio, they will come up. But it's important when thinking about planning for a loved one with a disability that you make sure that you want to maintain eligibility for those waivers. Let's talk about supplemental security income. SSI is a cash payment. I say cash, it's really a digital payment because it's directly deposited for individuals who are low resourced, under $2,000, and who are disabled. SSI is a program that provides a cash payment of up to $783 per month that is supposed to be spent on food and shelter, so rent, heating, garbage, adaptive equipment, or residential programs and support, okay? So the amount of money that an individual receives, the maximum is $783, is dependent upon whether the individual is working, whether the individual is being charged rent, whether the individual is receiving gifts outside of SSI. So let me give you a common example of an individual that I might assist. The individual is a 24-year-old person who is working part-time at a Kroger. And he receives SSI because he has under $2,000 in resources and doesn't earn enough that to take away all of his SSI. So he was originally eligible for $783 a month of cash from the federal government. And as he works, if he earns more than $85, then his SSI is reduced by the amount of money that he earns. Based on a formula, it's every $2 that he receives, they reduce his SSI by 1. So this individual works and receives SSI so that his income for the month is somewhere between perhaps $1,100, let's say, okay? So that's how SSI works. Now I work with lots of individuals who are not working and they receive the full $783 of cash payment. Now this cash payment comes into an account, a specific account for this cash payment, and an individual can manage that account themselves, provided they have the capacity to do that, or an individual can have a representative payee who manages those finances for them. In many of my client situation, a parent serves as the representative payee for their child. And as that child gets older, sometimes a brother does. So the $783 comes in, the representative payee makes sure that the individual has housing, has food, and then perhaps gives the rest of that money to the individual to spend on the things that that individual would like to do. So let's talk about eligibility. I touched on this a little bit, but the key thing here is that eligibility is limited to $2,000. So I've listed here also things that you don't need to worry about. Your assets are really cash or anything easily converted to cash. Those are the things that count. A home is not included. A car is not included. Household goods and personal effects. So you could have a fabulous TV that's worth over $2,000 and that's not counted. So really what we're talking about is financial cash assets. So let me tell you how that might work. Let's suppose that an individual is involved in an accident and they are going to need Medicaid, and also they want to make sure that they're eligible for every other government benefit. But they receive a settlement from the accident. Let's suppose that it was a person who was riding a bicycle and was hit by a truck. And that individual is going to receive a settlement from the insurance carrier. Well, we want to make sure that that individual is eligible for government benefits. And so what we do then is we don't have that settlement go to the individual who's been injured. Instead, we put that settlement into a trust that these two agencies don't count. So there are trusts available where the individual can have the benefits of Medicaid and SSI and the benefit of that settlement. So, for example, in that situation, let's suppose that the individual needs a wheelchair and Medicaid will pay for a $3,000 wheelchair, but the individual would prefer to have a $5,000 wheelchair. Medicaid pays their $3,000, the trust could pay the additional $2,000. Make sense? I forgot, I'm not live in front of you. Generally, I would say make sense, and I'd see heads nodding. So that's the way that I work with families. So let's talk about another type of benefit that you might hear about, and that's Social Security disability. Social Security disability is a person with a disability can receive that in one of two ways. The first is if that individual had worked the required number of quarters, they could receive a cash benefit based on how much they had worked. And oftentimes that is more than SSI. For example, if I were to become injured and not be able to work, I would be eligible for a payment under the Social Security disability insurance. What that means is I've paid in enough quarters, and based on what I've paid, I would receive a payment. Now, an individual with a disability, if the disability occurred before the age of 22, can receive SSDI based on their parent's work record when their parent begins to take Social Security. I'm going to say that again. An individual whose disability occurred before the age of 22 can receive SSDI based on their parent's work record when the parent retires and begins taking their own Social Security. For example, my law partner's daughter has a disability. She was receiving a cash payment from SSI until he started taking his Social Security. And her SSI payment then went to 1/2 of his Social Security payment without reducing his. So I have clients who thought all along they were going to take Social Security at 72 so that they could maximize their payment. But when they found out that their child could get half of their payment if they started at 66, they went ahead and took and retired at 66. Perhaps they continued to work, but their payment was based on 66, and their child then switched to SSDI and received more than the $783. In addition to that, when a person is on SSDI for 2 years, that person is eligible for Medicare. So those individuals will have Medicare and Medicaid. Medicare pays for what it does. Medicaid pays the premiums, and then they still have their waiver that's providing perhaps in-home care and support. So an individual with a disability can have supports coming from all different places. But in basic terms, the support comes from Medicaid, That's non-cash. It's services, whether that's medical services, day services, transportation services, camp, those kinds of things. And then they can receive support from the Social Security Administration, which comes in the form of a cash payment. Now, you heard me mention trust. Let's talk about trust. And the reason that it's important to talk about trust is because trusts are the key to allowing an individual with a disability to enjoy the benefits that they are eligible for, and also money that they should also enjoy the benefits of, whether that money is from a settlement from an accident or whether it's money left by a parent. So let's talk about a trust in general. The way to think about a trust, I think, is like a treasure chest. So imagine that if you're a parent and you want to leave money for the individual who you care for and love, who has a disability. Well, you know that you can't leave it directly to them. Maybe you knew that before, but you certainly know now because it'll be over that $2,000 limit. So instead you say, well, what can I do? Well, I would say to you, we're going to create a treasure chest for your loved one. And when you pass away, instead of leaving your treasure to your loved one, you're going to leave it in a trust for them. So the trust, the beneficiary in that situation is the person with the disability. They are the only person who can receive benefits from that trust. The trustee is the person who has the keys to that treasure chest. They are the person who decides what comes out, and the trust maker is the person who creates the trust. In my practice, that is either a parent, usually, or the beneficiary themselves. And we'll talk about that here on the next slide. There are 4 types of trusts that qualify for not counting as a resource. And when I say not counting as a resource, I want you to imagine that this treasure chest is going to have $2 million in it. It doesn't matter that this trust has $2 million in it. The person with disabilities, provided that they do not have more than $2,000 in their name, will get their waiver and will get their SSI. So, what is the trust there for? The trust is there to pay for the extra things that Medicaid doesn't cover. Ohio State football tickets. We all hope we can buy some this fall. The wheelchair, the glasses that are more expensive, the trips to see your brothers and sisters, the cruises that the individual wants to go on. That's what the trust pays for. Now, there are 4 types of trusts. One of those trusts allows for the money in the trust to go to other individuals when the beneficiary passes away. The other 3 trusts have some form of payback, meaning that the money in the trust after the beneficiary dies does not automatically go to other people. It either goes back to Medicaid to reimburse them for the services provided, or to charity. Now, the key here is there is no requirement that there be any money left in either of the or any of these trusts. So, how do we know which trust we can use? We know which trust we can use by where the money comes from, okay? So there was a movie out years ago called Jerry Maguire, and there's a scene where a guy says, "Show me the money." And so what I say to clients is, if you show me the money and where it came from, I can direct you what kind of trust to use. The most common trust that I prepare for individuals is the discretionary trust, this one right here. Now, the reason that people like it is because it does not require a payback. So that means that an individual, or excuse me, a parent can establish that treasure chest, leave money to it, and upon the beneficiary passing away, they no longer need it. It can perhaps go to the beneficiary's kids or brothers and sisters or anywhere else that the trust maker wishes it or wants it to go to. So I see lots of families in my practice, and they know that they have been assisting their loved one with their treasure. Think of treasure as money in the parent's pocket. And they've been paying for the Ohio State football tickets. They've been paying for the cruise or the trips. Well, that money needs to go somewhere so that the individual with disabilities can still enjoy those things. The parents leave that money to that trust, and it pays for everything Medicaid and SSI doesn't pay for. And when that individual passes away, it goes to wherever the parents have decided. That's the most common trust that I do. Now, the other trust that I do is called a special needs trust. And it's important to say something here. In the disability community, unless you work for Job and Family Services, the term special needs trust means anything that's going to keep my kid's waiver safe or anything that's going to keep my benefits safe. But when you talk to people in Medicaid, when they hear the word special needs trust, they're thinking of one type, and it's this one right here. This trust has a payback provision in it. It is the trust that I use to get people eligible for Medicaid when they already have too many resources. Let me give you an example. If a client came in to see me and they had been on a waiver waiting list and had been told that they were going to receive their waiver in 6 months, but they had to have under $2,000 in assets. And this client came and saw me and said, I'm going to get a waiver, but I have this money that my grandma put away for me in this account years ago, and it's $25,000. The first thing I would ask that individual is, well, is there any way to spend that money? Have you been putting off a purchase that you really want to make or need? Do you want to buy a car? Do you want to go on a trip? Does your house need renovated? And if the answer is no, or they'd rather not do that, I say, well, here's the option. Let's have you establish a payback special needs trust. We're going to put your brother in charge of it. He's going to be the trustee, and you're going to put your $25,000 into it. As soon as that $25,000 is in that trust, he is now Medicaid eligible and can get his waiver. Now, the next thing I say is, we should spend that money out of the special needs trust before you spend any other money, because we don't want to have money left in there. Of course, you can leave it in there if you'd like, but if you do need something before your parents pay for anything else that you might need, let's spend that money out of that trust. And you might be thinking, well, yes, I understand why, because that trust has a payback. And mom and dad, if they're not spending the money out of their pocket, they can leave that money to a discretionary trust that doesn't have payback. If I was in the room with you, I'd be saying, I hope that makes sense. And so I'm just going to explain it one more time. When we have a trust that has a payback in it, and we've got mom and dad who are assisting that individual with buying Ohio State tickets, we don't want mom and dad to spend the money for the Ohio State tickets while we have money in this payback trust. Have this payback trust spend it. Mom and dad now have the money that they would have spent on those Ohio State tickets, and they can leave it to the discretionary trust without a payback. Scrolling down. I've just talked to you about the discretionary trust, and I've just talked to you about the special needs trust. So I'm not going to talk any further or go through those slides point by point. Okay. What I do want to talk about next is the stable account. I believe that the stable account was a giant leap forward for independence for individuals with disabilities. And let me tell you why. Before the stable account came out, it was impossible for an individual with special needs or a disability to save more than $2,000. Okay, let me put that in perspective. Suppose you're an individual with a disability who's into astronomy and you want to buy an expensive telescope. You couldn't save more than $2,000 to buy that telescope because you would have lost your waiver and your SSI. So if you were in that case, you had two choices. First, lie and create commit Medicaid fraud. And instead of putting money in the bank, you put it under your mattress. Or you had to come see a guy like me and create a special needs trust. Now, I don't like special needs trusts, the payback ones, because they require an individual give up control of the money that they've earned or they deserve and put it in control of somebody else. I don't like that. Let me tell you a story. I have a client and he works at a grocer and he's pushing carts. And he might be pushing carts right now in the rain, and he pushes carts in the hot sweltering heat and in the cold of winter. The times when we're running to get into the store or getting into the store quickly as possible, he's out there pushing carts. And he had a problem because he couldn't spend that money fast enough that he was earning and getting with SSI. So he was getting and reaching that $2,000 limit. And his parents and he came to the decision that they didn't want to go out and basically spend that money at the end of every month for things that he didn't really want. Their quote was, "Logan, we can only buy so many Legos." So they were going out at the end of the month and buying Legos in order to get under the $2,000 mark. They decided they didn't want to do that. So they came to me and we established a special needs trust. So John's parents established the special needs trust, the payback. And John took his money, he's an individual with capacity, and put it into that trust. And his parents had the keys for it. So imagine that. He's earning money and he has to put it in some place that his parents control. Now there's a term for that. It's got the letters B and S in it. I don't know what you're thinking. I was thinking bogus. I don't know what you were thinking, but I'm thinking that's bogus, okay? It's bogus that he has to do that. Well, that was the case until 2016. In 2016, Ohio launched the Stable Account Program, and it is a special type of account. It is a special type of account that allows an individual with a disability to save more than $2,000 and not be ineligible for their benefits. And the individual can control the money. So, what are the requirements of the stable account? The stable account requires that the individual's disability occurred before the age of 26. I don't like that regulation. There is a push to extend that to higher so that individuals whose disability occurred post 26 can do a stable account. But what a stable account is an online account through the treasurer's office in which an individual can place their earnings, their SSI, their SSDI, and save it. So let's take that person who's interested in astronomy and they want to buy a $5,000 telescope. Well, now they can save that money in that $5,000 in the stable account. And you know what else? That individual can go to the store or go online and put their own card number in it, because Stable has a loadable debit card. So that individual now can save money and pay for the things that he or she wants. In addition to that, the Stable account is a great way for people to give gifts. So if a grandmother wants to give a gift to an individual who's receiving SSI, let's say it's $100 at Christmas. Technically, if an individual who's on SSI receives a $100 cash gift from a parent or a grandparent, they should report that to SSI, and the next month their SSI should be reduced. Now, I know that that doesn't always happen, but that is the law and the rule. If grandma instead leaves the money or the $100 gift to the Stable account, there is no reduction. The other thing that I like about the Stable account really is that loadable debit card. Because without this, what are individuals' choices for spending money? Well, it's cash or credit card. Many of the clients that I work with do not want to have a credit card. Particularly oftentimes their parents don't want the individual to have a credit card for fear that that individual might be taken advantage of. In addition to that, many individuals don't want to have cash because cash can be stressful. Why? Because cash involves change. And for many individuals, the math of change is not something that should go along with shopping. Shopping should be a joyous experience. When you go in and buy that expensive telescope, you shouldn't have to worry about whether you're getting the right change back. So the Stable account solves that issue and provides that has a loadable debit card. It's got MasterCard right on it. It's backed by MasterCard. It looks exactly the same as any other credit or debit card, and allows that to be loaded so that an individual can go in and walk into a Walmart, buy the things they need, use the debit card without fear that they have to worry about change, and parents don't have to fear that their credit card might be charged because an individual met somebody who took advantage of it. So it is an unbelievable, I think it's an unbelievable tool towards independence and towards just living a more wonderful life. I'm going to skip down to guardianships and advanced directives because we're right there at about the time that perhaps we want to take some questions if there are any. But
Logan,
also,
there is one question that came in over the chat.
great.
It's about special needs trusts. So the question was, is an irrevocable special needs trust the same as a discretionary special needs trust?
I don't know the answer to that. And here's why. An irrevocable trust simply means that when a person puts money in, they can't take it out. That's what irrevocable means. It also often means that the trust isn't changeable. A discretionary trust will, well, let me go back. A payback special needs trust will always have the statement that upon termination, the state of Ohio or any other state that provided medical assistance shall be reimbursed. The discretionary trust, on the other hand, will not have that payback provision. Now, it's important, though, that just because it's not a payback trust and it is a discretionary trust, doesn't mean that it will meet the requirements of Ohio. There have been cases out there. The most recent one was a case called Cook versus Job and Family Services, in which the individuals thought they had a discretionary trust that was going to meet the requirements. It was a discretionary trust, but it did not meet the requirements of Ohio to be one that didn't count as a resource. So I hope that answered the question. If it didn't, please put in the chat if I didn't cover that. If we were in the same room, I'd say, does that answer your question? And then you could say, no, you blew it, didn't work, and I could try to do it again. But I hope that answered your question. So a little bit about guardianships and alternatives to guardianships, okay? So an individual is presumed to be an adult who is responsible for his or her own welfare and decisions upon reaching the age of 18. Now, I certainly wasn't capable of taking care of myself when I was 18. But individuals with disabilities will often need assistance from other individuals to help them make decisions, whether those decisions are about services, classes at Ohio State, classes at Columbus State, the right transportation to pick. So there are two different ways that people get that assistance. One is guardianship, and the other is alternatives to guardianships. Guardianship is a legal relationship in which one person, called the guardian, is placed in charge of and in control of, and I'm using those words because that's what's in the statute. The guardian controls and cares for the individual. Well, it's not the statute, excuse me, it's the rules, different, but technicality, but because it's being recorded, I want that to be clear. That say that an individual will be controlled and assist another individual who is known in Ohio as a ward. I do not like that term, but you will see it in different types of publications and in the Ohio Revised Code. I prefer individual under guardianship. So a guardianship is a court-ordered relationship in which an individual is placed under a guardianship. A simple way to think about this is until a person turns 18, their signature means nothing. They are under the guardianship of their parent. At the age of 18, they are their own guardian. So I assist some clients in applying for guardianship for their adult child who needs a guardian. And the way that's determined is by getting a doctor well, this is how it's determined by the court. A doctor or a licensed clinical psychologist provides a statement of expert evaluation in which they state that the individual does not have the necessary capacity and competence to care for their health, well-being, and diet, or their finances. So a person, usually a parent, applies for guardianship over their child. And the child then, the person under guardianship, is then assisted by their guardian. It is the most restrictive means for assisting an individual with disabilities. And in fact, I oftentimes counsel people who come into my office thinking they need a guardianship, and we end up doing alternatives to guardianships because that is more appropriate. So alternatives to guardianships. So what I want you to think about is under a guardianship, rights are taken away from the person who is under guardianship and given to their guardian. In these alternatives, the person with a disability still has the rights. They are just allowing another individual to have concurrent or the same rights simultaneously. Let me give you an example. On the board or on the screen, you'll see durable general power of attorney. I have executed a durable general power of attorney that says that my wife can do anything for me that I can do myself. I want her to be able to sign a deed to our house if it needs to be sold. I want her to be able to sell my car if I can't. I want her to be able to go and call up my the custodian of my 401k and say, I need to take money out. She is my agent under a durable general power of attorney. So you see how this might work in a relationship that otherwise would go under guardianship. So I say to parents, maybe you don't need a guardianship. Would your daughter allow you to have these the opportunity and the ability to handle her finances while she maintains the ability to do it herself? And most of the time, if the person has capacity, they want to do that. Now, you've heard me use two different terms here, capacity and competence. Let me explain those. Competence is a legal determination made by a magistrate or judge about a person's inability to care for themselves or their finances. Capacity, on the other hand, is the ability for an individual to understand the document, the decision, and the consequences they are making. So a person could be who might otherwise need a guardianship, who could be found to be incompetent, another word I can't stand, could still have the capacity to sign a power of attorney. So what I like to say is we can always ratchet up to a guardianship. So maybe we start with the power of attorney, and if that doesn't work, then we move towards guardianship. Now, other alternatives to guardianships are things like a healthcare power of attorney, a HIPAA waiver, an assisted decision maker through the county board, a power of attorney for education. All of those documents could take the place of a guardianship if the person with the disability has capacity to sign them. Now, I'd like to walk you through a power of attorney. Okay, so this is a statutory form power of attorney. Now, I'm going to allow you all to read it on your own at your leisure, and I think the hard copies, have these been available for people to download?
I believe so, but if they're not, we'll make sure that everybody gets a copy and a follow-up email from tonight.
Okay, so here's what this does. This document is a document that can be used to avoid a guardianship. So I have this document or one similar to it, so that if I suffer a fall and I injure myself and my wife needs to make decisions or sell my house, she doesn't need to go and get a guardianship of me because I've already authorized her to sell my house. It's right here, okay? So when you read through this, the parts that you want to consider filling in are you. So you'd say I, and it would be your name, and then you name a person as your agent. Now, you can put more people in there. You could put I name Jane Doe and John Doe as my agent, okay? There's a part in here where you could say, and if they can't serve, I want this person to be my successor agent. Successor is the person who follows them. Now, when you name two of these, it says it up here, that if you name two, they will be, here it is. Co-agents are not required to act together. So if you put your mom and dad or your brother and sister, they can act independently of each other unless you say that they have to work together in this special instructions section. So what this document says is you can initial each of the things that you want your agent to be able to handle for you. So I would want my wife to be able to handle my real estate okay? If you have tangible personal property, like a collection of comic books that you would want your agent to be able to sell if they needed to provide you care, you would put your initials there. And you can go on down. Now, I usually suggest that if you trust your agent with one of these things, you should trust them with all of them most of the time. And so you might just consider initialing on line N that says they can do everything above. Okay? Then we go down to these express agents where you have to initial here as well. Okay? Now, most of these are not going to be of real consequence, okay? So I wouldn't get hung up on letting my agent create a trust for me. I would let them do that. Here's why. Let's suppose that I am a person who doesn't need a special needs trust right now, but I might in the future. So I want to make sure that my agent can take my money and put it in a special needs trust so I can get benefits. So I think that you might want to consider allowing the person to create a trust, make a gift, change beneficiaries, because we might have to do that. So again, I think that you might consider doing all of these subjects. And then you would sign this, and you're going to sign it in front of a notary. Notaries can be found at any bank, okay? And then I've also offered that if you want to reach out to me, we can arrange a time for you to either come into our office. We're practicing COVID-19 precautions, or I can meet you out in a parking lot with a clipboard and we can sign it there. Happy to do that at no cost whatsoever as a sort of a gift to the group. So I think that should cover. Well, I'd like to thank the folks here at Ohio State for welcoming me. I really appreciate NeuroNights. I love the name. I think it's terrific. I thought that was so cool when Jen told me that was the name of it. I think it's really, really neat, and I'm so honored to have been asked to come and speak to a nice group, but also that Ohio State thinks enough of me and the chronic brain injury department thinks enough of me to have me for a special evening. So thank you.